Yes, I'm George Peter Kaluma. I studied law at the University of Nairobi, graduated in 2000 with a Bachelor of Laws degree. I was among the best in that year. After that, I was given scholarship by the University of Nairobi, being among the best in our class to do masters. I did my master's degree in law and graduated specializing in law, democracy, and governance. I've practiced law very actively. We ran the firm of Lumumba, Muma, and Kaluma Advocates, with Professor P.L. Lumumba and Professor Albert Muma then. I've lectured law in several institutions. I'm among the pioneer lecturers at Kabarak Law School, which we established. I'm the first lecturer of administrative law, judicial review, and constitutional law, in addition to penology and a bit of criminal law at the university. I'm also the pioneer lecturer of trial advocacy at Kenya School of Law. By the time I joined Parliament, I'd just been engaged as a lecturer of law at the University of Nairobi. Currently, I'm the Member of Parliament for Homa Bay Town constituency, and I joined Parliament in 2013. I'm in my 13th year as a Member of Parliament in this third term. If we all remember, after the new constitution, that was beginning the 11th Parliament, is when we started enacted the various laws which the constitution required under the 5th schedule needed to be enacted by Parliament to fully operationalize the constitution. And so in the 11th Parliament, I was placed in the Justice and Legal Affairs Committee, and I was among the team that shepherded or gave lead in the enactment of those various laws mandated under the 5th Constitution. Most importantly, were anyone to look at Article 47 of the Constitution, there is the requirement that Parliament needed to enact the Fair Administrative Actions Act. And that is the statutory law in Kenya currently undergirding this area of law called judicial review in the public law area of administrative law. That was essentially a bill I originated, taking lead then as a member of Justice and Legal Affairs Committee. And so I've been in academia, I'm a scholar, I'm a legal practitioner. In most of my writings, I refer to books, not necessarily books, but I refer to cases I have been engaged to litigate as counsel. I've litigated or been an advocate in landmark cases, a number of which have been referred to in this book and in other textbooks I've written. I've written very many articles, refereed articles, I've written in journals, and so essentially, in addition to being a legislator and therefore having a greater and wider perspective of the subject matter of this current text, I'm a scholar, I'm a legal practitioner, and I'm a teacher of the law. Judicial review, law, procedure, and practice, which is the text we have published this time, is the third edition which we first published several years back. It is a book which is not just a revised edition in the sequel of the text we've been doing on the same subject. It's a book which has been wholly rewritten. A judicial review is the area of administrative law dealing with judicial control of maladministration or bad governance It's a very pertinent area across the country. The sequel or the earlier texts have been the best materials on the subject. From the first one to the second edition, which was published in 2012, but was ideally or largely a reflection of the law as of 2009. The publication of this book has become very necessary because since the Constitution came into being, there has not been a text on administrative law or judicial review on the subject in Kenya. And so, though the second edition was very rich, it has become necessary that we come up with this current edition for, amongst the many reasons, to bring on board the impacts the new Constitution of Kenya has had on the subject of public law in general, but also in the subject of judicial review and administrative law in particular. When the new Constitution was enacted in 2010, there was a requirement under the Article 10 of that Constitution that we have national values and principles of governance. Among them, Kenyans will find something called the rule of law. The people of Kenya talk about the rule of law, but if you ask them what does this thing we are calling the rule of law entail, they will not fully tell you what it is. In this book, I explain in very great detail the meaning of the rule of law, from supremacy of the law to equality before the law to procedural justice or the need for due process in all actions in which the rights or interests of individuals are affected. I go deep in the text to define what supremacy of the law is. Therefore, when you read through the book, you will get phrases like, "Be you never so high, the law is above you," to mean the preeminence or predominance or dominance of regular law above anybody. Be you president, be you king, be you anybody. And that I want to tell the people is the reason as to why you will find any judicial officer, even a magistrate, can summon the Inspector General of Police. The Inspector General of Police is required to abide. When we discuss a matter like equality before the law, you will get very interesting phrases, being discussed there. And so the new Constitution makes clarity that the foundation of judicial review of administrative law is now in the rule of law, something scholars before were worried about and was the subject matter of a lot of debates and writings without clearer agreement. A look at Article 47 of the Constitution gives now everyone the right to fair administrative action. And fair administrative action is indeed the greatest element of judicial review. And in that Article 47 of the Constitution, Parliament is required to enact the Fair Administrative Actions Act, which is to anchor judicial review, properly as a statutory subject in Kenya. And so that with that constitutional provision, judicial review, which was largely a Section 8 and 9 Law Reform Act realm of law, and an Order 53 procedural law subject, is currently anchored very firmly in the Constitution. In Article 50 of the Constitution, you have the right to fair hearing. And when you go into the chapters establishing the judiciary, you have the requirements of judicial independence and impartiality of tribunals. Now, the Constitution and the laws made pursuant to the Constitution The institutions established by the Constitution, like the Supreme Court, have done a lot of work. And while at least before this particular text, the highest court in Kenya was the Court of Appeal, the Supreme Court now is the apex court in the country. And among the mandates of the Supreme Court is to help with the development of jurisprudence. I'm saying this to make it clear the reason as to why the third edition of the text Judicial Review Law, Procedure and Practice is now a necessity. And I'm saying that is so because with the new constitution, there are lots of changes which have impacted in a very huge way on the subject of judicial review, public law, and administrative law in the country. I'm saying this book becomes necessary because the previous editions of the text were treating the law before the new constitution. And so that even if you look at the law reports, the cases referred to those previous, editions of this very book, you will find them not focused on, not referring to any case in the Supreme Court, and even where they referred to cases of the Court of Appeal and the High Court, they related to the old constitution, the current constitution. So the additional reason as to why this book is becoming necessary at this time is to bring on board the very many cases which have been decided, particularly by the Supreme Court in this critical area of law, to bring on board the cases which have been determined by the superior courts, both Court of Appeal and High Court also, on board around this subject. But those cases so deeply change the sphere of law in terms of the concepts and their clarities. So my motivation has been to come up with a version of the text on judicial review that discusses the impact of the new constitution, discusses the impact the new institutions like the Supreme Court have had in this particular subject, and that brings apace all developments in this area from the angle of court determinations, and of course from the angle of the rich Bill of Rights that the Constitution puts together. The target audience for this book will be, number one, the law practitioners. And for law practitioners, I'm talking of lawyers, I'm talking of advocates in legal practice, I'm talking of judges across all our courts, and of course all judicial officers. A critical target area is the students of law and teachers of law or the academia. The book has been written in very simple language, and so it is easy for any ordinary person interested in good governance also to just get a copy and read through it. More so when they may want to understand the details of simple things we talk about, like right to hearing, the details of simple things like natural justice, what does it entail? The requirement that anybody deciding anything must be impartial, what does it mean? When we talk the rule of law, what is it? So it is a book that is recommended to anybody who is a believer in good governance. Like the previous editions, this book has very many sections. As a scholar, at the very beginning, the text deals with the foundational and historical issues. And it will be noted from the text that at that very beginning, the foundation of judicial review is being traced from the ultra vires doctrine to currently the rule of law. The history of judicial review in Kenya is being traced from 1956, when it was received from England, to the current time following the enactment of the Constitution of Kenya, 2010. After those foundational discussions, the book focuses on the regular practitioner. And so the next chapter of the book deals with the procedure, the practice of judicial review. Let me tell Kenyans that judicial review has been a very technical area. Before the new constitution, the current constitution, if you just failed to draft pleadings in judicial review in the manner prescribed, that action would be struck out straight away. And so to help the regular practitioner, the book does not just deal with how you approach court in terms of the procedure, how you draft documents, and what documents you need to draft when you have a case for judicial review to take to court. But at the back of the book, relevant to that, you find the form or precedents to guide you in terms of how to draft them. So that beyond the regular practitioner, even an ordinary litigant can take those forms, fill them up as already set out, and they'll be able to argue. Into the book, we discuss the orders which can be available to a litigant or a Kenyan in an action for judicial review. And traditionally before, we had orders like certiorari or quashing orders. We had orders like prohibition. We had orders like mandamus, and then they were restricted to those three. With the new constitution, if you are moving to enforce the Bill of Rights, you can seek now declaratory orders, you can seek orders of injunctions, you can seek orders of damages, you can seek conservatory orders, and in some circumstances, the court is granted powers under Article 23 to give such orders as it would deem fit to secure the cause of justice. So those orders are all discussed in detail in terms of the circumstances under which they can be sought, the law governing their issuance, and when they can be denied, including orders relating to costs in very great details. The most important chapter in this book to the regular practitioner of the law, whether in the bar or the bench, is a chapter dealing with the grounds of judicial review. Those grounds a person needs to have to be able to invoke court process to seek orders available to them in judicial review. And there are very many. The ultra vires doctrine is discussed in detail in the text. The idea that any authority given power must keep within the confines of the powers given, and that when an authority goes beyond the powers donated to them by law, they are said to be acting ultra vires or ultra vires. That is a potent ground for judicial review. The ground of unreasonableness, or what is called Holsbury's unreasonableness, remains a potent ground for judicial review and is discussed in the text. The ground of taking irrelevant consideration or failure to take into account all relevant considerations when deciding on a matter or taking an administrative action remains a potent ground for judicial review, and it is discussed very deeply here. Grounds like bad faith. If an authority acts in bad faith, anybody can go to court and of course request the court by way of judicial review to countermand such decision. So the new grounds of judicial review, like proportionality, like legitimate expectations, have been developed in Kenya largely because of the freedom and liberty we were given by our courts to expand the scope of judicial review. And I'm thanking Justice John Nyamu. John Nyamu is the judge who helped us to establish the Judicial Review Division of the High Court. People are forgetting. But by the time we completed university, you could barely have your hand upon a determined case on judicial review. And if you read most of judicial review decisions, especially at the High Court, you get Judge Nyamu's name on them. Among the judges they were with in the High Court at the time, this new, grounds of court intervention by way of judicial review are being, come up to. The Supreme Court Judge Isaac Lenaola, Supreme Court Judge Ibrahim, Judge Warsame of the Court of Appeal, I'd mentioned Judge Anyara Emukule, Judge Jackton Boma Ojwang of the Supreme Court, then in the High Court. And I want to thank them in a very special way for the contribution they made to the development of those grounds and expanding the scope of judicial review as a pertinent subject, not just of legal practice, but for securing justice to Kenyans under the current constitution. The most important ground for judicial review has been, of course, separately discussed in a chapter in the book, and that is the ground of natural justice as a ground of judicial review. And natural justice has been discussed in very great detail. Wherever you move across, people tell you, my right to natural justice has been infringed. But if you ask them what natural justice within the context of law really entail, they have problems with it. So the two principles that underlie natural justice, both the right to be heard and the rule against bias, have been discussed in great detail, and our whole chapter have been committed to their study. At the level of right to be heard, what does it entail? The requirement of notice, the need to cross-examine anybody giving oral evidence against you, the need for legal representation where cases are complex and technical, all those details, the requirement of oral hearing in some circumstances and written memorandum and others, all those entailments of the right to fair hearing have been discussed. Maybe to emphasize that in the discussions on natural justice, particularly on the rule against bias, very recent cases have been, discussed in great detail, including the recent determination by the Supreme Court to bar particular advocates from ever practicing from those courts, from a legal standpoint, of course, as an author without taking sides. We discuss also in the book what has been called the legal standing or locus standi to institute and maintain court action by way of judicial review. People have forgotten how far we have come. There was a time Professor Wangari Maathai wanted to institute action to prevent the building of a skyscraper somewhere in Uhuru Park here. And she was denied audience by the High Court. And the judge just said she was not the one breathing oxygen. So it's about environmental pollution. She had to prove that she interacted with oxygen far, far better than any other common person. And because of that, the action was struck out. In discussing locus standi following that case, to date, we are now saying that anybody that believes some constitutional provisions touching on fundamental rights and freedoms are being infringed has the right to approach the court. And by the way, due to those changes in law, you've seen so many people whom I've acknowledged in the book, like Okia Mtata, the Citizen, can take any matter to court, and the court would not chase him away. So I discussed there how the independence of the judiciary has been treated over time. Very big now. People do not know the judiciary now, once parliament budgets, have their special financial independence in the sense that all that money budgeted or appropriated to the judiciary is given to them straight away, and it goes to the judiciary fund, and it is administered by the registrar. away from the influences of the executive here. Seen the courts being built, the decisional independence of judges is beyond range. And so that you can see our judges today, you go to court, and they don't give a damn that it is a member of parliament, it is a presidential candidate that is there. They'll make a determination and enjoy that realm of decisional independence without any qualms. And so the idea of judicial independence, the various instruments that undergird it, and how it should be approached under the new constitution have been captured in this book. And that is why I say that this particular edition has become very necessary, because we need to have a text on administrative law that is in full accord with the new constitution and the developments in terms of jurisprudence coming from courts since the new constitution was published. And so those are key sections. Again, at the back, you'll get annexes which detail various international instruments which are core in this area. The other interesting thing that you will see in this book is that the book combines the features of a textbook in terms of being able to explain principles in a very simple language to anybody who cares to learn about those principles or who wants a reference material to go to. And also the features of a case book, so that you get very many outstanding cases, or what we call classical cases, referred to in the text. It is a book for a newly admitted judge and who is posted to the public law courts. You are posted to the Judicial Review Court, have the book and you have your Bible in terms of being able to be in a position to determine any cases brought there. You're a student of law studying administrative law, or this particular facet of administrative law called judicial review. Just pick this book. The language is very simple. You don't then need to wait for the lecturer to go to read. So it combines the features of a textbook and a case book all at once in very simple language. And that is a quality that you will not get in any book. The book has been written from various perspectives. There is the perspective of a member of parliament, things like delegated legislations, their merits and demerits. And by the way, I'm among the first members of parliament to serve in the Committee on Delegated Legislation. And so we discuss a number of topics, matters like legislative sovereignty in the context of the United Kingdom as against constitutional supremacy in our constitutional setup here, are being discussed with perspectives which you cannot get in other authors of public law outside there. The book then has the perspective of a scholar, and then you have the perspective of a teacher of law and a regular practitioner in the area all at once. And then the writing also, is targeted to meet all those sectors. I want to say that for anybody interested in good governance, for anybody interested to practice in the area of administrative law, for every student of administrative law, for anybody who is teaching administrative law, for anyone who is privileged to be a judge in our superior courts, having a matter on administrative law to determine, this becomes an inescapable handbook and a friend that you must have. And there will be justice in every matter or treatment of any issue you have before you. I want to acknowledge a number of people for their contribution, for their inspiration, for their support, for just being there to share thoughts or to refine a number of thoughts which have found their way into this text. I was taught law by Professor P.L.O. Lumumba, this subject. And being my foundational lecturer in it, I want to appreciate and acknowledge the excitement and the inspiration he gave me in that regard. In fact, among the first texts I wrote on administrative law were co-authored by myself and Professor P.L.O. Lumumba, and for that I remain eternally grateful. Just when I was done with the book and just and sent it for publication, it will be noted I acknowledge some 2 senior counsels who went ahead of me. Unfortunately, they have passed on before the book came out on print. There is Judith Ongori, senior counsel. May our good Lord rest her soul in eternal peace. She passed on when I acknowledged her contribution in enabling access to justice to the downtrodden. And I have not changed the acknowledgement to confirm that now she is passed on. And this is because by the time of the news of her passing on, the book was already out for print. I want to thank her for the contribution made in public law. I want to acknowledge her for the mentorship she was always available to give to people in matters public law and matters family law. And we always pray to God to rest her soul in eternal peace. Again, just before this book went on print, we were hit with the news of the passing on of Roslyn Adhiambo Odede, the Kenya National Commission on Human Rights chairperson. Was just buried a short while back. Roslyn, as the chair of Kenya National Commission on Human Rights, and previously as the vice chair of the Judges and Magistrates Vetting Board, manifested great heart, great spirit, and great understanding and appreciation of the need to protect human rights and fundamental freedoms for all. The time of her death, Kenya was faced with very serious issues of human rights violations, and she did not flinch. I want to acknowledge her posthumously for her contribution, and by the way, her acknowledgement will remain among other distinguished people in this book. There is a Kenyan who has been the emblem of public interest litigation, and that is citizen Okiya Omtata. Okiya Omtata has courageously taken cases to court nobody would take to court. And though not a trained lawyer, he studied those cases, he understood the subject matter, and his intervention vide public interest litigation has helped a great way to develop, the jurisprudence in public law. There are a number of cases he took to court which I've referred to in this text, particularly when treating the matter of judicial independence and the rule against bias, up to the Supreme Court. This is the only Kenyan who has succeeded to disqualify the whole bench of the Supreme Court, and not even an advocate of the High Court of Kenya or an advocate in Kenya has ever done that. And he successfully did it. And those cases have been referred to here. For that innovation, for his courage, for his bravery, is saluted. And we want to hope and wish that he continues, for development of the law needs people truly needs people like him. Putting together rough ideas in a text like this is never easy. And so let me acknowledge my assistant Penina Samba for the effort and the contribution she made in helping me to refine better the ideas I had into the matters which have come to this text. Lastly, it has never been easy. And for those who have not written and those who have not authored any text, you cannot talk of a book this size without appreciating the publishers. Law Africa and their team, Ronald Ndambuki, and of course the leadership of this organization have been very patient with me. Across the publication, there are times I've required the publishers, their staff, people like Ronald Ndambuki, to sit with me over the weekend. Because in my current status, sometimes I only have time that weekend. They have never bothered or never refused to come. We've sat with some of the staff of Law Africa deep into the night. And sometimes they have suffered a lot of pain. There are instances where whole chapters have been written and rewritten. Up to the time of print, we were still correcting punctuation marks like commas, like full stop. I want to appreciate and acknowledge the Law Africa for the patience, and I want to appreciate them for the sacrifice in terms of time and for ensuring that this book is coming out in a text form that is comparable to none in the country, but that is comparable to those ones at the international standard. So I truly appreciate them for a good work done, and more so in the area of referencing the footnotes, the indices, the annexes, all the references. You point at any you want, you'll get it exactly the way it is done. And for ensuring my verbose grammar speaks, to the simplicity, to the matters, the subject matter of this book in that simple language. I'm very grateful to them. To all who believe in good governance, this is the text for you. I invite you to get your copy from the Law Africa and make it your friend. And an judicial review will always grow.